we will discuss about law of tort. Before that, I would like to introduce my group member. Me as first presenter, Nur Hazwani Ghani. Second presenter, Nur Azah Ayu Maksum. And third presenter, Shamira Muhammad Isa. First, what did you know about the law of tort? Okay, it is a severe wrong committed by one individual against another, and it is a form of corrective justice, and its principal function is to compensate victims for injuries inflicted by tortfeasors by virtue of their conduct. It has the breach of duty owed to the injured party, which breach of duty has in fact caused the injury. Okay, for objective of tort, there are four. First is compensation, protection of interest, deterrence, and punishment of wrongful conduct. First, what is compensation? The purpose is to provide a channel for compensating victims of injury and loss, whereby issues of liability can be decided and compensation assessed and awarded. Next is the protection of interest. It is to protect a person's interest in land and other property in his or her reputation and in his or her bodily integrity. For example, the tort of nuisance protects a person's use of enjoyment of land, and the tort of defamation protects his or her reputation, and the tort of negligence protects the breaches of more general duties owed to their person. And then the deterrence, law of tort have the deterrent effect, encouraging people to take fewer risks and to conduct their activities more carefully, mindful of their possible effect on the other people and their property. And lastly, the objective of tort is punishment of wrongful conduct, which is in law of tort. There is a certain symbolic moral value in requiring the wrongdoer to pay the victim. Okay, this is the chart of torts. It has the strict liability, trespass, the person, chattels or property, and then on the case it has the negligence and the nuisance. Okay, next is type of tort. There are 6 types of tort. First, negligence, defamation, intentional torts, privacy torts, nuisance, and strict liability torts. Will be discussed each of the type of tort. First is the negligence. What is negligence? It's actually the breach of legal duty to take care, which results in damage to the claimant. So in this negligence, it has the elements. What is the elements? It has 3: duty of care, breach of duty, and plaintiff has suffered the damage. Okay, first is duty of care. For example, suppose A is driving his car on a busy road and in a busy town. Okay, the fact that he is driving in a busy town means that he is in the situation whereby there will be many people around, and any ordinary or reasonable person would realize that if A does not drive carefully, he may cause the injury to someone or damage to the property of another. So, in this case, A therefore has a duty of care to drive with care and skill so that no one is injured. Okay, regarding the case in the negligence, there are cases from the Donahue versus Stevenson, 1932 Act 562. Okay, the defendant, a ginger beer manufacturer, had sold ginger beer to retailer. A bought a bottle and entertained her friend, the plaintiff, who drank the ginger beer. When A refilled the glass, along with the ginger beer came the decomposed remains of a snail. So the plaintiff shocked and was severely ill as a consequence. The plaintiff sued the manufacturer and claimed that the manufacturer had a duty in the course of his business to prevent snails from entering into his ginger beer bottles, and further that he had a duty to ensure that all empty bottles were carefully inspected before they were filled with ginger beer. So what is the issue whether the defendant owed such a duty to the plaintiff? So this is the significance of the decision of Donahue versus Thompson case. First, negligence is a separate tort in its own right, and action of the negligence can exist whether or not there is a contract between the parties. And then an action for negligence will succeed if the plaintiff can prove first, a duty of care is owed by the defendant to the plaintiff, and next is breach of duty that by the defendant, and then resulting the damage which is not too remote. Okay, in order to establish the existence of a duty of care, the never principle based on reasonable foresight must be applied. And lastly, the manufacturer of drinks owes a duty of care of the consumer not to cause the injury by negligently allowing the snails from contaminate the product. Okay, next element is the breach of duty. Okay, once it established that the defendant owes the plaintiff a duty of care, the next step is to consider whether the defendant has a breach on that duty. Okay, put simply, breach occurs when the defendant does something that is perceived to be below the minimum standard of care required of him, which is measured through the standard of a reasonable man. So, the reasonable man test, a breach of duty is determined through the reasonable man test. Okay, for example, would a reasonable man have acted as the defendant has done if the reasonable man was faced with the same situation as the defendant? Okay, and the third one element is damage. Okay, the plaintiff needs to prove is that damage was caused by the defendant's breach of duty. Two issues need to be addressed in determining whether the damage suffered by the plaintiff is the consequence of the defendant's breach of duty. So the first issue is the causation in fact, and the second is in the causation in law. So what is causation? It is relevant in all tort, in that the plaintiff must prove that the defendant has caused his loss. Okay, I would like to pass to the second presenter, Nur Azai.
Thank you, Hazwani. Now I will continue with defamation. What is defamation? Defamation is false statement about a person that is likely to damage their reputation in the community. Or you can say defamation exists when there is a publication which has a tendency to lower the person's reputation or to cause him to be shunned or by reasonable person in society, thereby adversely affecting his reputation. Elements of defamation. Number 1, the words are defamatory. The words have a tendency to lower the estimation of the plaintiff in the minds of right-thinking members of society, so that the plaintiff is avoided, shunned, or ridiculed. The plaintiff must know what has been said by him and cannot merely guess. If the odds are merely words of abuse uttered in anger in the height of the moment, then the word will not be defamatory. Second, words must refer to the plaintiff. Defamation is that the words must refer to the plaintiff. When the plaintiff has proven that the words are defamatory in nature, he must then prove that the words refer to him. Number 3, the words must be published. Publication means that the dissemination of the defamatory words or material to a third party other than the plaintiff, the person is defamed. Types of defamation. There are two types of defamation, which is number 1, I'll explain you slander. Slander is the defamation in a temporary or transient form. Publication is usually made through spoken words or gestures. A slander is not actionable per se. The plaintiff therefore needs to prove actual or special damage in order to succeed in his action. The preferred term is actual rather than special damage, and where reference is made to special damage, it is synonymous with actual damage. Types of spoken defamation are speech or gesture. Number 2, types of defamation is libel. Defamation in a permanent form and is usually visible to the eye, such as items in writing which includes email, pictures, statues, or effigies. Section 3 of the Act provides that the broadcasting of words by means of radio communication shall be treated as publication in a permanent form and therefore constitute a libel. Libel is actionable per se, which means that the plaintiff need not prove any damage. This is because the law presumes that when a person's reputation is assailed, some damage must result. A bank commits the tort of defamation if it wrongfully prints the words "account closed" on a check that is in fact bound to honor. Written or printed defamation are film, books, or letters. This is a case of Luke Kai Lam versus Sim Island, which is an example of slander to women. Section 4 of the Act provides that the publication of words which imputes unchastity or adultery to any woman or girl requires no proof of special damage for the action to succeed. In this case, the respondent called the appellant a prostitute and said that appellant charged 50 ringgit to entertain men at any one time. These allegations were made in the presence of a third party. The court held that since the words impugn the appellant's chastity, special damage need not be proven, slander were established. Intentional torts are assault, battery, false imprisonment, nervous shock, trespass to land, trespass to chattels, trespass to person, and conversion. Example of trespass to person. Assault. The tort of acting intentionally and voluntarily causing the reasonable apprehension of immediate harmful or offensive contact. Assault also defined as an intentional and direct act of the defendant which caused the plaintiff reasonable apprehension of the immediate infliction of a force unto his person. Battery. Battery is defined as direct application to force to another person without the person's consent. This touching need not necessarily involve violence. False imprisonment. False imprisonment defined as the restriction of a person's freedom of movement. The person so restrained is imprisoned so long as he cannot move to another place in accordance with his precious time. Nervous shock. Nervous shock occurs where a person willfully does an act that is intended to cause physical injury to another and that does in fact cause a reasonably foreseeable physical harm to them. I will pass you to my friend Mira to describe more about the coming slide.
Thank you to Nur Hazwani and Nur Azhar. Okay, I will continue with the trespass to land. The tort of trespass to land consists of directly entering upon land or remaining upon land or placing or projecting any object upon land in a possession of the claimant in each case without lawful justification, and it also intentional physical invasion to land without a legal excuse. Okay, ways in which trespass may occur. Okay, there's three situations here. The first one is entering upon land. The second one is trespass to the air space. The third one is trespass to the ground beneath the surface. Okay, I will start with the entering upon land. Okay, it's a situation like walking on tall land without permission or refusing to leave when permission has been withdrawn, or throwing object on tall land. All example of trespass land. Okay, the second one is trespass to the air space. Okay, it's a situation where trespass to the airspace can be committed. For example, in Kelson versus Imperial Tobacco Company, 1957, 2QB 334D, which is committed trespass by allowing an advertising board to project 8 inches into piece property at ground level and another above ground level. Okay, the third situation is trespass to the ground beneath the surface. Okay, here example case in case Bully Coal Mining Company versus Osborne, 1899 Act 351. The Dees mined from their land through to the Peace land. This was held to be trespass the subsoil. Okay, next is trespass to chattel. Actually, trespass to chattel is unlawful taking or harming of personal property of another without consent. In other words, chattel is a legal terminology for personal property. Okay, here we have a type of tort of goods. We have 3 type of tort of goods. The first one is trespass to goods. Second is conversion, and the third one is detenue. Okay, for trespass to goods, is defined as a wrongful and direct interference with goods that are in a possession of another. Okay, for conversion, it's occur when a person deal with another good in a manner that is consistent with the plaintiff right to immediate possession. Okay, the third one is detenue. It's a situation and action for the wrongful detention of goods. It is initiated by an individual who claim to have a greater right to that immediate possession than the current possessor. The possession become illegal due to the withdrawal of consent by the owner of the goods, who initially may have consent to the defendant having possession of the same goods. Okay, we go to the privacy tort. Here we have 4 types of privacy of tort. Okay, actually privacy of tort is an intrusion into the personal life of another without legal justification. It include first, misappropriation, second, intrusion, third, false light, and the last one, disclosure. Okay, we go to misappropriation. Misappropriation occur from using another name, likeness, or identifying characteristic for commercial advantage without his or her permission. In this situation, a plaintiff must show his or her name was used as a trademark in advertisement or in packaging. Okay, for intrusion, is an invasion by the defendant or plaintiff execution in a manner objectionable to the average person. So here plaintiff must have a reasonable expectation of privacy to make this claim. Okay, for false light, the defendant makes a widespread dissemination of a major misrepresentation of plaintiff activity or belief that would be objectionable to the average person. So it's similar like to defamation but become broader. Okay, the last one is disclosure. Okay, disclosure is a public disclosure of private fact. Is a widespread dissemination of confidential information. Okay, for nuisance, a person in possession of real property, either land or owner or tenant, are entitled to the quiet enjoyment of their land. So if the neighbour interfere with that quiet enjoyment, either by creating smell, sounds, pollution, or any other hazard that extend past in the boundaries of the property, the affected party may make a claim in nuisance. Okay, here we have a category of nuisance. The public nuisance. So public nuisance is arise in consequence of following particular traits by which the air is rendered offensive and noxious, from act of public indecency, as bathing in a public river inside of the neighbouring houses, or fact tending to a breach of the public peace, as for drawing a number of persons into a field or the purpose of pigeon shooting, the disturbance of the neighbourhood, or keeping a disorderly house, or a gaming house, or a bawdy house, or a dangerous animal known to be such, and suffering him to go at large. So, as a large bulldog accustomed to bite people, or exposing a person having a contagious disease as the smallpox in a public and the like. Okay, for the private nuisance, is a continuous, unlawful and indirect interference with the use of enjoyment of land or of some right over or in connection with it. So in action for private nuisance, the plaintiff must prove interference with the enjoyment of his land. Therefore, a plaintiff must have an interest in land to be able to sue in private nuisance, unlike a claim based on public nuisance, which does not require the plaintiff to have any interest over land. Okay, the last one is strict liability. Okay, we have three types of liability. The first one is liability, which is imposed on the defendant without any proof of fault on his part. Okay, the second one is vicarious liability. Is a situation that possible of law for a person to be held responsible for the act or omission of another, even though they may not have been personally at fault. Okay, the last one is occupied liability. The liability of an occupier of premises for any damage suffered by visitor to the premises. Okay, that's all for our group presentation. Thank you for watching this video and bye bye. Have a nice day.